So today we're going to talk about the topic of bail reform. TJ kind of briefed you prior to the interview. So the first question is, what happened in 2016? What did voters vote for?
So in November of 2016, they voted on a constitutional amendment that did two things. It determined that judges should have the constitutional authority to detain dangerous defendants pre-trial, talking about the time between when they get arrested and when they go to trial, get their case resolved. And number two, it re-emphasized the constitutional provision that you shouldn't be held in jail pre-trial just because you're poor, because you can't afford to pay a bail bond. You should be held if you need to be held because you're a risk to public safety.
Can you explain the public safety tool that followed?
Well, the Supreme Court authorized courts to use risk assessment instruments if they chose to. The one that was adopted first in Bernalillo County, which was ahead of the other counties in this regard, was the public safety assessment, the Arnold Ventures tool, the Arnold tool, some people call it, public safety assessment. Because it's really well-researched, well-validated instrument for helping judges get information they need to set good release conditions for defendants based on their risk level, not the charge level or some other thing that really doesn't predict whether they're a threat to public safety.
So early on, after bail reform was passed, there was some criticism of the judges. Was that criticism fair?
Well, it depends on what you're talking about with regard to what kind of criticism. Like any real sea change in the way we do things, there's a period where we all had to adjust. Everybody in the criminal justice system, prosecutors, defense attorneys, us, the defendants, although they wouldn't necessarily know it was change, because it really was a very different way to do things and a way that is based on evidence of what will increase public safety and get cases going through the system. We want resolution, right? We want someone to be adjudicated. Did they do the crime? Let's find out if they're convicted or acquitted, and let's do that in the period where they're between arrest and that. Let's maximize public safety while respecting the rights people have to be not held in jail. You're not supposed to get punished before you get convicted. So we shouldn't be, almost all people, we shouldn't be putting them in jail until they go to trial. They should be out doing what they do until they're convicted.
6 years later, how do you feel about the bail reform system?
I'm very excited about the progress we've made. We, the Administrative Office of the Courts, have implemented evidence-based pretrial in roughly half the counties, probably two-thirds, 65–70% of the criminal population, because we have pretrial in places where there's more concentration of people in criminal cases. We've implemented in a way that we think follows national best practices, and the data, most exciting thing to me is we have a lot of data not produced by us, but from outside independent researchers who've looked at what we're doing and said, by and large, you're on the right track. There's always things you can do to improve, and we're always on the lookout for that. It's one of the reasons why we give all of our data to researchers and say, tell us how this is working, and we can see maybe where we see areas we should improve. But it's really great to see the data telling us exactly what we'd hoped it would, which is that we've increased public safety, we've increased appearance rate. Those are the two things we look for in pretrial. Do you come to court when you're supposed to, and do you not get arrested for a new charge during the pretrial period? If we succeed in those two things, then pretrial is a success. If you get arrested for a new crime, we consider that a failure. Not because you necessarily committed a new crime, but there's at least probable cause, and that's the best thing we can do. If we waited till you got convicted, we'd never know. So we treat arrest as a failure on the public safety side.
So does the data show that the changes are working?
Absolutely, yes. The data shows that not just here in Bernalillo County, but also in all the counties in which we've implemented evidence-based pretrial practices, the before and the after show increase in public safety and increase in appearance rate. And that makes good sense. That's the whole point of using evidence-based risk assessment rather than we'll set a bond on everybody based largely on their charge and hope that if they're dangerous, they can't make bond or something like that. That's a much better practice than what existed before. And I think when people look at the system and they want to criticize it, it's important to remember what we had before, which was just random whether a dangerous person got released or not. You could be a very dangerous criminal that we know we shouldn't let out of jail, but you have access to enough money to pay your bond, you can fund it through a bondsman, you'll get out, even though we really know you shouldn't be out. Now that's very different.
So we've heard so many people, right, refer to the revolving door here in New Mexico. What does the revolving door mean to you?
It's a perception by people that somehow when people are released pre-trial, instead of being just held in jail, that it increases the amount of criminal activity in their community. And I think that perception is fueled by the kinds of things that attract public attention, which is there are times, and there are always going to be times, when someone is released pre-trial and they do something extraordinarily bad, a horrific crime. And that will happen once in a while because we can't perfectly predict human behavior. Our whole effort in this evidence-based scientific approach to risk assessment is to really minimize the time that that's possible to happen. But it could happen with anybody. Somebody could be released for a simple fourth-degree felony and go do something horrible. But what really gets the public's attention is somebody who they think, well, wow, we should have kept that guy in jail, and they get out and they do something. And that will happen. But the evidence shows it happens extraordinarily rarely, maybe 1% of the time. The Institute for Social Research, which is the University of New Mexico social scientists with PhDs who employ a lot of formulas I don't understand, looked at 20,000 cases, and they said people who are on pretrial release who get arrested for what we call a violent felony make up less than 1% of the people on release. Now, people will say, and I've heard it said fairly, if one person is released and they commit a murder, that's one too many. I agree. We certainly, believe me, judges aren't looking to release people who are going to do something terrible. But there are two things that restrain their ability to detain defendants. One is judges can't detain someone unless the district attorney brings a motion to detain them and proves they're too dangerous to be released. If that doesn't happen, the judge must release the person on whatever conditions a judge can impose that will maximize public safety, short of keeping them in jail because they don't have that authority. So I think it's really important to remember all parts of the system need to work in order to maximize public safety.
How difficult is that balance for judges, right? Because as a judge, you have to uphold innocent until proven guilty and public safety. How difficult is it to make a decision based on those two principles?
I think it's one of the hardest things that judges have to do. You have constitutional principles. We can articulate them. Almost everybody should be released. You're presumed to be entitled to be released. After all, you haven't been convicted of a crime. On the other hand, you have a history maybe, or the particular crime of which you're charged. The evidence is pretty good and it's pretty horrible. And there's a risk in letting you out that you might behave that way again. That would be awful. And if the judge doesn't have a motion in front of him or her, it's even harder because they can't detain them. They can't say, I know this person shouldn't be out, but I got to release them. So I'll do everything I can. Maybe they put them on a restriction of curfew, maybe an ankle monitor. They make them use pretrial services, try to keep them on the right track. But that makes it even harder. But even when there's a motion, the judge has to decide if the prosecutor has presented enough evidence that the person is so dangerous we can't protect public safety through other means. And that's one of the most challenging things I think judges in the criminal arena have to decide. And they live in this community. They have families and children here. I have family who live right here in Albuquerque. Nobody on the court side of the system is interested in doing anything other than maximizing public safety within the context where, unless we have evidence otherwise, we really have to let most people out until they're convicted.
We mentioned the fact of bail and then now. People were able to get out on bail, right? So I guess where I'm going at with this question is it any different? I mean, people were getting out on bail, people are getting out now. Are those percentages really any different, or were people just getting out to begin with?
Oh, yes. Many, many, many more people are out now than were out before. Because under the money bail system, I did an awful lot of work here in Bernalillo County, for example. About 60% of the people in the detention center, the Metropolitan Detention Center, were there because they couldn't pay their bond. It might be $100, $500, $1,000. Many, many people charged with crimes don't have that means. They're living paycheck to paycheck. Hopefully they're working, they're productive members of their community. If you put them in jail for a month, 5 months, 6 months, a year, even if you dismiss their case at the end of that, they don't have a job, they don't have a place to live. An employer asks them, what have you been doing for the last year? They say, well, I've been in jail, but I didn't do anything wrong. okay, they're going to have a hard time getting a place to live. It does a lot of bad things. Those people are 4 times more likely to be convicted of an offense within 3 years of the finishing of that first case when they're held in jail rather than when they're released. And the great majority of those people, when they're released, are going to do everything they're supposed to until their case is resolved. They're not going to get arrested for another crime. They're going to make their court appearances. So it's a tremendous difference because so many more people are released under the current system, and yet the appearance rate and the arrest rates are lower. The appearance rates are higher, sorry, and the arrest rates are lower. So I think that the evidence shows we're much better off now than we were before.
Perfect. So I'm going to read you here what the voters voted for on that constitutional amendment. So we pulled it up, and this was the exact language. To protect community safety by granting courts new authority to deny release on bail pending trial for dangerous defendants in felony cases while retaining the right to pretrial release for non-dangerous defendants who do not pose a flight risk. Now, do you believe this makes it sound like more people were going to be held in jail?
It may. I mean, I can't tell exactly how people are going to read the language. That's the description that was provided, I think, by the Secretary of State's office, the actual language, but it gets you to the same place. They should think we're going to detain more people because you have to remember before, almost nobody could lawfully be detained pre-trial. Now, a judge could, out of serious concern for public safety, set a high bond, a $50,000 bond on someone who appeared to have no money at all. That person could still get out. They might convince their relative to pledge their house in order to get a bond for a $50,000 amount that gets you released. Or they might have access to funds that aren't apparent when they're in court. Very few people were held pre-trial because we decided they were too dangerous. A great majority of people who were held because they didn't have enough money to get out. It seems to me it makes a lot more sense to keep, we'll probably keep fewer people in jail now because we release all those people who are poor but who aren't going to present a real threat of public safety. But we have the ability, and judges regularly keep people in jail when the prosecution makes a motion to detain, and they're dangerous. And that's, I think the public, reading that paragraph, if they understood that, they would have voted for it because we're much better off if we're keeping in jail dangerous people and we're letting out those who aren't dangerous who, they get convicted, they'll pay their price. But until then, we treat them like we would like them to continue to be able to work and go to school and go to church and do all those things.
Sure. There's been a big question as to whether that ballot measure was clear. Do you think it was clear to the voters?
Yes. It only says 2 things. It wasn't very long. It says we're going to give judges the authority to detain people, felons, when there's a motion by the district attorney, and we're not going to keep people in jail pre-trial because they can't afford their bail bond. Let's set conditions that relate to their risk factors, not, they got charged with something, so it's a $500 bond. That doesn't protect us at all. It just keeps poor people in jail and lets people with, however dangerous they are, with the means to pay, the ability to get out. And that's not a good system. I think, I hope they understood if they did understand it, they would have voted for it. 83% of them voted for it.
Perfect. So we were told that bail reform was created so that people who couldn't afford bail would not remain in jail. But the constitutional amendment didn't address that, nor is there any mention of what a defendant can afford when they have their initial hearing or preventative detention. Why is that? Because
money is not a relevant factor in whether someone should be released pre-trial or not. It has nothing to do. It has a little bit to do with flight risk. If you're charged with a serious crime and you can flee to an non-extradition country, sure, money might play into it. We don't have those defendants. What we have are the great many defendants who, like many of our folks, depend on their job to keep them employed, to keep them housed, to keep their relationships going and all of that. When they're charged with a crime, they should get what they deserve depending on the outcome of the criminal justice system, but keeping someone in jail on a bail bond because they can't afford it punishes them for being poor before they ever get convicted of any crime.
So the DA told us one of 2 things could happen. He said there is no longer bond. Is that correct?
No, that's not correct. In the conditions of release that a judge can set, this is created by court rule, Supreme Court rule. There's a presumption they're supposed to be released. There are conditions a judge can impose, a set of conditions depending on how the judge evaluates that person's risk level. Detention is a whole different thing because the judge doesn't have that option unless there's a motion by the DA. But short of that, there's a whole list of things. And a bail bond can be used by a judge if the judge believes it's necessary to avoid flight risk. Paying money doesn't make you less dangerous. It may make you more likely to stick around. If you're going to lose $10,000 if you don't show up to court, okay, maybe you're more likely to show up. A great many of our defendants, they don't have $10,000, $1,000. If they get out somehow by paying at 10%, that they're not worried really about that. So the money doesn't really have anything to do with dangerousness. It can have something. You can impose a bail bond if you can articulate, you the judge, can articulate, we need a bail bond because I'm concerned they're going to flee the jurisdiction. Mostly meaning not that they're going to flee to Cuba or something, but they're going to not show up for court. So if we put some money in, they'll show up. But it's significantly reduced the use of bail bonds because mostly what we're worried about is conditions that will make us as safe as possible while that case goes through the process.
Now, the ballot measure says dangerous defendants can be denied bail. What is a dangerous defendant to you?
Well, we try to give judges as much information as possible so they can make an evaluation of dangerousness. Again, they can't detain them all by themselves without the DA filing a motion and presenting proof. So they have to evaluate every defendant based on what evidence is presented to them. But we can give the judges information such as the public safety assessment, which is a risk assessment instrument that says based on the person's, well, there's 9 factors that are considered, age, previous criminal, do you have a current pending charge? That's about the heaviest factor that goes in because that indicates, you know, you might be dangerous because you're getting arrested repeatedly, things like that. So we give them a PSA score to help them know that this person's background indicates they have this kind of risk level for not showing up or for getting arrested for another crime. We also give them a BIR, a background investigation report. So AOC has an operation here in Albuquerque that provides statewide to judges criminal history investigation. So they'll tell the judges about arrests, all kinds of things that don't necessarily mean just convictions of crimes. And so the judge has that information as well. So our job, AOC, pretrial, is to give the judges as much information as possible so they can make an informed decision about what kind of conditions they want to set on a person, who they are going to release, unless there's a motion and they conclude that the person shouldn't be released.
So there's been a lot of pushback on the public safety assessment tool. Why is that?
I'm not sure. I think if people take the time to understand what it actually does, they'd be more comfortable with it. For example, a great many people, from what I see in the media, think that the PSA tells a judge what to do. So if you score this level, the judge just has to do this thing, or if you score that level, the judge has to do this other thing. That's not true at all. The PSA doesn't bind the judge's decision in any way. It's information for the judge. So based on an awful lot of research, which takes a while to explain why this makes sense, because some of it's counterintuitive, a person has this risk level for getting arrested again or not showing up to court. Based on that, we can tailor conditions to that person. We have pretrial services. If you come to pretrial services regularly, it really reduces the incidence of failure to appear and rearrest rate. We use tools like electronic notifications because people don't necessarily not show up to court because they're, you know, trying to pretend they don't have a criminal charge. They don't remember, they're not organized enough to know they're supposed to be there. They forget. A reminder, just like you have a dental appointment. Well, if you probably miss your dental appointment half the time if you don't get that little text reminder that says, Wednesday is your appointment. That's how these things work. So I don't think criticism of the tool itself is justified. There's a tremendous amount of validated, peer-reviewed research about the public safety assessment that indicates it does have value in showing the risk factors for people. And when the ISR, the Institute for Social Research, validated the PSA for Bernalillo County, and we're undergoing our second validation now, you want to get your instrument validated against your population. Are you doing the right things? Is it predictive? Is it actually working? And then if it's working, is it biased against women, minorities, all kinds of things. And that's what you do in a validation study. The first time they did it, 3 years ago, I think the report was released, they said, yeah, it is doing what it's supposed to. It's predictive. It doesn't guarantee, if I have a certain score, doesn't mean I'm going to behave the same way as the guy next to me who has the same score. But overall, these people with this kind of background are at this risk, this level of risk for getting arrested, for example, during the pretrial period. So it is predictive. It's, I think the most important thing I'd like people to know, if they think it tells the judges what to do, that's not the case at all. It gives them information about a defendant that they can use to make their independent decision about what conditions we should put on that person to increase public safety and assure that they'll come back for their court hearings.
I mean, you're essentially asking a tool to predict human behavior.
Yes, understanding that we know it's not going to predict human, it's going to tell us someone who's a 6'6", which is the highest risk level, clearly has a much more likely chance they're going to get arrested, for example, during the pretrial period than somebody who's a 1'1" or a 2'2", right? So you want to use that information to know that they're riskier. Now you look at all the other circumstances you know about them and you decide, do I need to put a curfew on them? Do I need them to come back to court every week? What conditions do I need to put on this person? Is it a drug problem? Do I want them drug tested? That kind of thing.
Do you believe the current system adopted in 2016 has led to an increase in crime?
Oh, certainly not. So if you look at the data, and I do, that's released by APD, particularly here in Bernalillo, for example, crime has gone up, crime has gone down, and we've had the pretrial system in place. Historically, back in the early 2000s, crime was much higher than it ever has been since we did pretrial reform. But it has gone up at times. We've had, obviously, the murder rate has been just horrendous. And that's the worst crime, obviously, a homicide. You won't find the police or the prosecutor able to say it's pretrial defendants who drove our murder rate up to 140 or 150 people a year, because it's not true. A person on pretrial release could commit a murder, of course, but it's not why we set new records, the last 2 years. Maybe this year it's less. I just saw data released by APD that show significant reduction in crime, although drug crimes went way up, not because we have more drug crimes, but because they decided to focus on drug crimes. Very few people call in and say, I want you to arrest someone who's using drugs. But the crimes we worry about, the crimes against persons, the violent crimes, house burglaries and things like that, they've gone down. The data on pretrial shows that for the pretrial population, which is just a slice of the criminal activity, they're less likely to get arrested during the pretrial period, and they're more likely to show up to court. So if those two things are true, then pretrial isn't driving an increase in your criminal rate. I could show you the 15% of the people who get arrested for a new crime during their pretrial period here in Albuquerque. The huge majority of them are fourth-degree felonies, misdemeanors, and petty misdemeanors. Now, a fourth-degree felony can be a serious matter, obviously, to any victim. That's very important. They're crimes. They should be punished if you get convicted. But it's not a first-degree felony, which would be a homicide, all the worst, kinds of crimes you think of with serious harm to people, or even a second-degree felony, and even not very often a third-degree felony. So the pretrial population really isn't, they're not getting arrested for the things that really worry us the most, murder and all those, terrible crimes. So, we don't, I don't have research that says pretrial resulted in crime going down this much, but I certainly don't have, I've never seen anybody produce research that says what we're doing, the kinds of things we're doing here, or if they're done in other places, have increased crime. And it makes sense if more people are coming to court and fewer people are getting arrested, and we're releasing more of them, well then, it's not responsible if your crime goes up. There are a lot of factors in the system that have to have interplay with each other. And I'm sympathetic to the need for more prosecutors, more defense attorneys, police being able to do their work with folks, out on the street. Diversion programs, because a lot of crime is driven by people who have co-occurring disorders, right? All that is great. But I can tell you that the data on pretrial, which we've studied extensively, shows those people come to court more frequently than if we didn't do what we're doing, and they get arrested for new crimes less frequently than if we didn't do what we're doing.
If it's not the system that's causing an increase in crime, then what is?
Well, that's far beyond my area. Obviously, in the courts, we're responsible for the people who get arrested and charged with crimes and getting them through the criminal justice system. But I know that we've gone through a tremendous period of social upheaval. There's a lot of questions about the economy, certain people being left out of the economy and all of that kind of thing. We know that economic challenges generally drive crime up. Over many decades, you'll see that's true. So I can't say what has driven the data up in Albuquerque. Same way I can't say why it's gone down recently, which of course is a trend we hope continues. But I can say that we do look at the data very closely to see what we can do to mitigate the pretrial population being responsible for crime, that is getting arrested while they're on pretrial. And we do that. Not 100% of the people that we release come through without getting rearrested. And there are consequences for rearrest that can cause you to have more restrictive conditions put on you, including detention. So there are, of course, other factors that could drive crime. I think anybody who went through the pandemic could understand social disaffection, all kinds of issues. But that's not my area, so I can't say for sure. What I do know is when we talk about the way people see things, I don't expect Channel 7 to ever run a story to say, today, not a single person on pretrial release got arrested for a crime, or this month. Or it's, like those job sites where they say how many days since an accident. It's been 62 days since somebody got arrested for a serious crime who was on pretrial release. What does get attention is when someone on pretrial release gets arrested anyway for something really horrible. And that is going to happen because we're dealing with human beings and we're going to have to release most of them. And I understand that, and I understand why that creates a perception that the people on pretrial are doing bad things. But overwhelmingly, they are not, in fact, doing bad things. I mean, as I said, the UNM folks at the Institute for Social Research looked at 20,000 releases since 2017, and they found very few, a minuscule number of them, who got arrested for something you would consider a serious crime. But those who got arrested, I guarantee you, they were on the 6 o'clock news, and that's what drives perception. But we know we're not in, the people who are in pretrial get arrested for new crimes at a very low rate.
Can you explain the various conditions of release that the court can put on someone?
Oh, sure. Everything from, I'll give you a court date, you come back to court next month, which is, nothing, right? Just, you got to come back to court. To detention if there's a motion. They can just keep you in jail because you're just too dangerous. If there's a motion by the DA and they show they're dangerous. Short of detention, which a judge can't do on his or her own, everything from reporting to pretrial services, so engaging with them in weekly contact, can be drug testing, although that has to be very specific to a drug-related crime, all the way up to a curfew. You have to be in your house by 8 p.m. every night because your risk is being out with your friends, all night, creating bad situations. In limited cases, electronic monitoring can be used to enforce a curfew, or you're not allowed within a half a mile of your alleged victim's home. It could be your wife or girlfriend or whatever. And so we monitor them to see if they go in that zone, they're going to get an arrest warrant and they'll be brought back in front of the judge. So, from nothing to just come back to court all the way through electronic monitoring, which is about like being in, it's not like being in jail. It's the closest thing to being in jail because you can't go where you want to, do what you want to all the time, and we'll know if you violate the conditions. And anything in between that the judge thinks will help you. Now, we're not punishing people, so we can't say you have to go to drug treatment. We can offer drug treatment, say, that's one of our programs we have. But pre-trial, we're really interested in, are you going to come to court and are you going to get arrested for a new offense? And those are the conditions. The judge uses conditions to enforce those two, to improve the likelihood those two outcomes will be good.
And are those conditions as effective as holding someone in jail?
Well, if you're in jail, you're not going to commit a new crime, although, of course, we do have crimes in jail where people stab other people. But forgetting that, if you're in jail, you're not going to be out committing a crime, for sure. But if you wanted to make sure nobody who is charged with a crime gets arrested for another crime, we keep everybody in jail. Well, that would be extraordinarily expensive to us, the taxpayers, and it would be extraordinarily ineffective for public safety purposes because, as I said, if we kept everybody in jail, it's going to take 6 months to a year to get their case resolved. And during that time, they're going to lose their job and their home, and they'll come out much worse off, even if the outcome is they get acquitted or the charges get dropped. So, yes, having someone in jail can't go rob the 7-Eleven, right? Somebody who's not in jail can. But we try to identify the people that are the greatest risk to do that and make it so they don't get out, or they get restrictions that are so restrictive they won't be able to rob the 7-Eleven or hurt someone, while everybody else gets out because, after all, that's what the Constitution says should happen. If my daughter, one of my daughters, got arrested for a crime, I'd be very grateful that there's a presumption they'll get released and that I don't have to find enough money to get them out. I have to show that they're not dangerous. Regardless of what they're charged with, they're not dangerous to the public.
So we've heard there's a shortage of ankle monitors in the state. How many do we have?
I can't tell you an exact number. We try to, the evidence-based practices tell us, and this is from a lot of research here and elsewhere, that the ceiling on the number of people who warrant an ankle monitor is about 10% of your released population, and generally it should be lower. It depends on, judges' decision making about how to mitigate the risk of some defendants. It takes a lot of education to understand where they're effective ankle monitors and where they're not. Remember, there's two different situations in which ankle monitors are used. People are convicted of crimes but given probation. They're often put on an ankle monitor so that we can see if they're drinking or if they're driving out of the county or whatever it is they're doing. Most defendants who haven't been convicted of anything are free to go wherever they want to go and go to work and do their things because that's their constitutional right. But for those who merit an ankle monitor, we try to make sure we make sure that it's being used on the right people and that the resource is there. If there's not enough, I would listen to my judges and my pretrial staff from a court say, you know what, we need more electronic monitoring resources for these reasons. And if they made sense, if they're using evidence to make the argument, then we would be able to provide them with more resources. But if they want to put an ankle monitor on 50% of the people that are released, I guarantee you the evidence doesn't justify that. It just makes us feel better because, after all, we'll know where the person is or something like that. You have to also remember, I live in Santa Fe. When the court in Santa Fe, they put someone on an electronic monitor, there are a lot of folks who live in places where we're not going to get a report from that little radio signal on the weekends because they're at home, and where their home is, the signal doesn't go out. So then when they leave home to go to work on Monday, we'll get the whole weekend's worth of activity. They were at home. So you have to consider that too. It's not really a panacea. It is a good tool for those people who warrant it, who merit it. Like often, whether we're worried about them being in the proximity of a particular victim, or their history says they're dangerous. If we need to keep them home during certain periods of the day so that they don't have the opportunity to go out and engage in behavior that's going to put the public at risk.
So do we need more ankle monitors in New Mexico?
No, I do not think we do. We're not done implementing in all jurisdictions. We'll have some counties, some districts now don't have any electronic monitoring because they don't have any pretrial. We'll introduce electronic monitoring there and work with everybody there. I should say, when we put pretrial services into a county, into a court district, which is usually multiple counties, we convene a stakeholder group and work for months to figure out what's the best fit for this jurisdiction. And those stakeholders include the district attorney, the sheriff, the public defender, the jail, they don't call them warden, the people running the detention center, and of course the courts, the judges, and our pretrial staff. And they all work together to figure out what fits best for that jurisdiction in terms of everything, the whole gamut. And that would include electronic monitoring.
Now, the DA, AG, and governor say there needs to be a legislative fix to this. Do you agree with that?
Well, of course, it depends on the legislation. There are legislative suggestions on which we don't comment because, well, obviously, we'll enforce whatever law gets passed and, see what happens. I would say the courts would definitely support, for example, if the DAs are saying we're understaffed because we don't pay people enough, please give them more money to pay people more. Same thing on the public defender side. That's not the courts. They don't work for me. But, we need the right resources in place so the system can work. The LFC has done a lot of analysis of data, including particularly in Bernalillo County, and said that the most effective thing we could do on crime here would be to have swift and certain justice. Because if people know they're going to get arrested and that they're going to go through and if they're guilty get convicted, it reduces the level of crime. It causes them not to engage in the behavior. Well, we're only a piece of that, right? We're in the middle, but we would definitely support a legislative effort to give more resources to the other parts of the criminal justice system. Behavioral health resources, great, because we see a lot of the people come through the criminal justice system need behavioral health services. So I guess that would be my answer on legislation. We've been asked, for example, about lots of other things to affect pretrial. Some of it we'll comment on, some of it we don't. We just say, what I say to legislators is, if you have an idea for something that you think would make people safer, I would be happy to tell you if there's data, research, information, and evidence about how likely that is to achieve the objective you want. If the evidence shows it's not going to achieve the objective you want, you could still pass a bill and enact it, but you're probably not going to be happy with the results. We're very interested in supporting anything that evidence-based research shows will improve public safety.
So I'll ask, and if you can't comment, you can't comment. But our district attorney here in Bernalillo County, Sam Bregman, he told us during his interview that he's really going to push for rebuttable presumptions. What are your thoughts on something like that?
So there are people better equipped to tell you about the data around that. I think you're talking to Dr. Guerin from the Institute for Social Research, for example. They published they published studies about presumptions. We ran a study 2 years ago on 929 defendants who had a detention motion and had been released, and how they did. Actually, they did better than the average population in terms of not getting arrested and things like that. But a huge percentage of them would have been detained under a presumption system, and yet that huge percentage of them, the great majority of them, didn't get arrested for anything, and they showed up to court. In fact, none of them got arrested for a first-degree felony. So I would look at the data. I would ask those people who, pull apart. We give them our entire database of everybody who's been released and what happened with them, and they follow them through to conviction, acquittal, dismissal, whatever happens. And they say, here's what happened. And if you had been presumed detained, and so you'd been detained for a particular charge, if you read the data, it'll tell you that really doesn't help you achieve what you want. So, when those pieces of legislation are in front of the legislature, we really don't comment on them. We don't take a position on them because that's a policy determination to make. If you want to have presumptions and you want to enact them, certainly you can, and we will enforce them as long as that's the law. But we urge everybody involved to look at the evidence about whether that's going to get you where you want to go, make you safer.
So the Supreme Court has made several different rulings when it comes to bail reform. Can you explain to us some of those rulings and what they mean? Sure.
So they've done two things. They've changed the rules twice since implementation in 2017, largely to at the request of prosecutors to give them a little more time to make a decision when someone's arrested about whether they want to move to detain them. I should say, they can move to detain a person anytime they want. They don't have to do it in the first 3 days after an arrest or something. They could do it a month later when they find out this person is more dangerous than we thought. Let's bring a motion to detain him. So they have changed the rules. But they've also issued a series of court cases to help judges and all the folks involved in the criminal justice system, prosecutors and defense attorneys, understand how the courts are going to apply the constitutional amendment and the rules that relate to it. This year, they issued a ruling, which was an appeal from the district here on a denial of a detention motion. And they reversed. And they said, there seems to be a little bit of a misunderstanding about how this standard is applied. And they clarified what judges should be thinking about when they're determining whether to grant or deny a detention motion, which we hope makes the system work better. And that's how the law works, right? If there's something wobbly about the system and it comes in front of the court, they have a chance to fix it or to say, well, this is what the law requires, you can change the law. So what the court has done through those cases is try to set out how you make a decision about any kind of release condition, one set of cases, and how detention motions are to be decided. And detention is a very serious matter. We certainly want judges to feel empowered to detain those who are dangerous and to make the right decisions whenever they're faced with a detention motion, because deprivation of liberty is also a very serious matter for someone who may or may not get convicted of a crime. When a bail bondsman posts a bond to get someone released from jail, they undertake one responsibility and one responsibility only, and that is to get the person to court. They're at risk to lose their bond amount if the person doesn't show up. Now, under our statutes, it's very hard to forfeit that money, but that's a whole different matter. They have no responsibility whatsoever for public safety. But when you see a television show about a bounty hunter, which is a kind of bail bondsman, I suppose, they're going after people who have put the bail bondsman at risk for losing the bail amount because they didn't show up for court. So even though it looks like a police activity and they break into homes and they do all these things, which doesn't happen very often, rarely happened in New Mexico, that kind of thing. They're doing it because of the financial interest the bail bondsman has in making sure the person goes to court. If that person committed a string of bank robberies but they come back to court, the bail bondsman has no risk whatsoever. It may be that the bail bondsman could make an argument that we help make sure people come back to court. And that's great. We have pretty good appearance rates under the current system. I don't know that they have data to show they would do better. They didn't do better when it was release on bail bond alone, because we had a lot of people in jail who weren't released. But anyway, I want to be real clear, because people get the mistaken idea that they also protect us from these guys, like they're somehow keeping an eye on them so they don't do anything bad. And they have no legal responsibility whatsoever to do that. And in my experience with the bail bondsmen, they were worried about protecting their financial interests. After all, that was their business, right? So if you're going to lose $50,000 that you put up because you said someone would come back, you're going to want to go find them, yes. If that person is released today and they fail to appear, we're going to issue a warrant and they'll get arrested sooner or later. Why they have a large backlog in Bernalillo County is a confluence of a lot of factors. We have a lot of warrants out all over the state. In the pretrial context, and a lot of those are, other contexts than pretrial. In the pretrial context, we work very hard to make sure our appearance rate is as high as it possibly can be. That means we're doing what the bail bondsman would do, that is making sure they get back to court. And they're coming back to court about 90% of the time in most of our jurisdictions. Some higher, some lower. That 10%, there'll be a warrant and they'll get arrested sooner or later under the warrant. So, we have a large accumulation of warrants. We got a lot of those when we had bail bondsmen being much more active in the state. And if they posted a bond on someone, they might help get them back to court, because that's their business model. But they didn't have anything to do with public safety. And we do work very hard to get people into court. For example, we do what's called a safe surrender program. We just did one in Taos. We had 1,000 people show up because we told them we're not going to arrest you if we can avoid it at all, which we do for almost everybody who shows up. We say, look, you got a warrant issue because of this matter. We can take care of it right now, or we can set you on a court date, for wherever anywhere in the state that your case belongs. and get it straightened out. But you got to be in compliance or you're going to get arrested. And if we can avoid arresting 1,000 people and putting them in jail for a week while we get them straightened out with the court, that's better for those people. It's better for us. It's better for law enforcement who doesn't have, arresting on a warrant can be a risky proposition for a law enforcement officer. And it doesn't mean we spend $100 a day for 5 days for someone who, they want to, obviously they go to the safe surrender. They want to get this taken care of. That's a lot better than if they're pulled over for speeding and they have a warrant and then we got to arrest them. And so I'm not sure that the bail bondsmen have a lot to say about how they could improve public safety, but they can make an argument about their responsibility to return people to court, especially when they had a large financial risk that we don't use that anymore largely. We can make a big bond amount if someone is a flight risk, but we just don't have. It's hard to predict someone's going to be a flight risk unless they're skipping from state to state and committing crimes or something.
Sure. Now, with the safe surrender, do you believe more people are using that safe surrender than, say, being picked up on the street by a police officer?
No, I would hope that, that law enforcement are enforcing warrants all the time. They do. I know it for a fact they do. And they arrest people who have a warrant. And if you forget about your court case and the judge issues a warrant and the address on your license isn't where you live, so you never know about it, you'll get arrested when you get pulled over for speeding or something. And the more serious people, obviously, there's a lot more active efforts by law enforcement to find the dangerous ones. So I know those people are getting arrested. When we do a safe surrender event, we advertise it, we try to get, let everybody know that this is going on, because it's just a more, it's a safer, more effective way to deal with people who, by and large, they don't have a warrant because they're running from the law. It's because they forgot to show up for court, or the day they were supposed to go to court, they had to go to work, they didn't want to lose their job, and then they knew they had a warrant issue because they didn't go to court. Now they're hoping nobody will find them. It's a good way to resolve that, but that's just a small part of all those warrants that are outstanding. We're going to do a safe surrender event here in Bernalillo County through the Metropolitan Court. That may help. But what happens when law enforcement does warrant enforcement, they arrest people and they go to jail and they go from there in terms of fixing things. When we do a safe surrender, almost completely, those people don't go to jail. We get them back on track with their case by and large. Those are the people who do safe surrender.